This slide file will present the process of preparing a subpoena to collect evidence at a crime scene. Subpoenas are a legal tool. This abstract will generally explain the purpose of the subpoena and procedures of general evidence collection, transport, preparing for evaluation and examination of evidence. Before preparing a subpoena and having it served, begin with the end in mind. The U.S. legal system is based on facts, integrity of evidence, case law, statutes, verdict, adjudication, and punishment via sentencing. Properly gathered evidence supports the facts of the case, and maintaining its integrity via a chain of custody document to allow the evidence to be admissible in court. The Daubert standard provides an accepted scientific methods of evidence analysis and credibility of expert testimony that will be admissible in court. This evidence and facts are deliberated, leading to a fair and just verdict. Before preparing the subpoena, we need to identify what evidence is needed to incriminate the suspect. Know which items or testimony are missing to incriminate the suspect that shows a crime was committed. What evidence will prove a crime was committed? Where would the evidence come from? Is the testimony of knowledge needed from the suspect? Is the suspect likely to comply with the terms of the subpoena? Or will a court order or search warrant be needed to follow the subpoena? Remember that evidence proves that a crime was committed to harm a person or a legal entity. It's important to compare the difference between a subpoena and a court order because they are different. It's reasonable to surmise that the subpoena is the first legal tool that's used to gather evidence. Its intent is to collect specific things of value for an attorney to incriminate a suspect, and there are penalties for non-compliance. State, federal, criminal, procedural laws, subpoenas offer attorneys a chance to obtain information to help prove or disprove their client's case. It often comes from an attorney representing a party to litigation in which the government entity is not directly involved. It's noteworthy that a subpoena can come from a court, but often comes from an attorney. We notice the last item in the subpoena is that it doesn't come from a judge and lacks the authority of a court order. Sometimes it can come from a judge, yet a subpoena may not have the same kind of authority as a court order. The court order could be the second legal tool that's used to gather evidence. Its intent is to order the entity to do something. Stiffer penalties for non-compliance would exist. It's signed by a judge mandating the entity to do as the judge orders. And if an entity opposes the release of data pursuant to a court order on the grounds that the data classified as not public, the entity's staff should consult an attorney to look to the state statutes. Sources of evidence in this case could include digital devices for business and personal use, fixed and mobile storage devices, cloud storage accounts, login credentials to online accounts and devices, encryption keys to access accounts and data on devices, and printers to print documents and reports. The memory in printers will include what's been printed that can help support intent of a crime. We'd want to know for the source of evidence Is the defendant or the suspect likely to comply with the terms of the subpoena? What penalties are there for noncompliance? Evidence proves that the crime was committed to harm a person or a legal entity. We want to look at the pros and cons of a subpoena. The pros being one that's prepared correctly, and cons being perhaps it's prepared incorrectly or it has not been complied with. The pros are that the evidence that's requested is relevant to the facts of the case, it's prepared correctly, the preparer appears competent and suggests credibility, the suspect complies with the terms of the subpoena, the evidence is simple to gather and preserve, the forensics report and expert testimony are admissible in court, and the forensics report incriminates the suspect. The cons are that the evidence that's requested is inadequate to support the facts of the case. Perhaps there are technical omissions rendering the subpoena incorrect in preparation. If so, and the evidence requested is inadequate, it could make the preparer to appear overreaching, asking for maybe more than is needed, or inept. The defendant is non-compliant. There are only some evidence is turned over, and the methods or the holes in the forensics report fails to incriminate the suspect or is inadmissible. It's important to note that there are different kinds of evidence. The police forensic practitioners are trained to collect, preserve, copy, examine, and report on evidence that is often non-digital. It tends to be more tangible in nature. Digital forensics practitioners are trained to collect, preserve, copy, and examine and report on digital evidence. It's very different than the police collecting evidence. And when digital evidence is collected, a specialist in evidence collection should be hired. Collection of evidence should maintain the personal safety of the collector. Wherever the collector is going, if their personal safety is at risk, that should be secured before entering the site. Do we need testimony of knowledge from the suspect? Is the suspect likely to comply with the terms of the subpoena? If the suspect is non-compliant with the subpoena, do we enforce penalties or follow with a court order or a search warrant? Know before the subpoena is prepared, know what the goals are. The state and federal criminal procedural laws, subpoenas offer attorneys, said before, to obtain information to help prove or disprove their client's case. Write the subpoena specific enough to identify the items to collect. Write it broad enough to accommodate field conditions for items that closely match the description in the subpoena, and clearly state the penalties for non-compliance. The content per the state of Minnesota, per the link provided, there is procedure and content of the subpoena. There is a format, can be in a pre-printed form or conform to format. There are means of serving the subpoena, protection of the person subject to the subpoena. There are duties in responding to the subpoena, and the penalties for non-compliance, often with contempt. Next is, once all the evidence is gathered, once the subpoena is served, there is a protocols to transport the evidence to maintain its integrity. Evidence should be collected to preserve the unique and authentic conditions showing that harm was caused. Preserved evidence can incriminate the suspect. The transport, storage, and handling of authentic evidence is essential to maintain its integrity. Authentic evidence intends to incriminate the suspect. Original evidence is handled at the collection site to preserve its integrity. Forensics practitioners are trained to collect and preserve evidence at the collection site for its transport to a lab. Safeguards to maintain the integrity of the evidence would be following protocols and procedures to handle the evidence to maintain its integrity, how the evidence is stored at the collection point to preserve its authentic state. The chain of custody form is prepared and maintained. It documents who handled the evidence and when while in protective custody. And evidence is collected, is secured per the protocols and procedures to transport to the lab for protective custody and handling. Protocols of transport preserve the authenticity of the evidence. These were the references used to draft this slide.